most recent, I think, publicity was really over some judicial and court filing housekeeping. We have been on a trajectory towards the Montana Supreme Court, and we are still headed towards the Montana Supreme Court. Essentially, what it boils down to is, the university system is in court because we have been sued for student records that we are not, at least at this time, authorized to publish or to release in any manner if such records exist. The United States government has told the Montana University system that we are to provide Mr. Krakauer with nothing in response to his request for student information. Some folks might recall that a while back, a state court in Helena decided that Mr. Krakauer should have certain student records, but the United States Department of Education, the United States government, sharply disagrees under a matter of federal law. So that's how we have ended up at the Montana Supreme Court. The Montana University system's only objective in this whole situation is to do the right thing. So that means that we have to protect the legal privacy rights of all students unless and until a court of competent jurisdiction were to ever direct us to do otherwise.
Now, what would happen should a court, perhaps even the Montana Supreme Court, side with Mr. Krakauer and say you must release the records? Because I understand the last time you and I talked that this had much more far-reaching effects than just revealing confidential information about one student. It could also endanger the very funding that the public universities receive. Is that correct?
That is our understanding under the messages from the United States Department of Education. So what this really boils down to is that from a federal perspective, the United States Department of Education and the United States government is not overly concerned with what the prior state court ruling was. Their position is if there's any conflict between state law and federal law, that the federal law is controlling. And the United States government, the U.S. Department of Education, if it finds a state or a university in violation of federal student privacy laws, if it finds that a state or a university has illegally breached or violated the privacy rights of students, then under express federal law, among the sanctions or the penalties that are provided for in federal law is the removal of federal funds. So because all state universities and colleges in Montana accept federal funds, then the U.S. Department of Education has that authority to remove federal funds. The largest source of federal funding for Montana colleges and universities is our acceptance of student federal financial aid, such as Pell Grants, any financial assistance that students receive to get their foot in the door to be able to afford college. So it's that type of federal funding that is at risk under the law. Now, I will say that when we have explained that point and that fact in the past, Mr. Krakauer has responded or replied in a way of skepticism, if you read the legal briefs, basically saying that the U.S. government would never remove federal funds for violating the federal law. However, that's what the statute says the U.S. government has the authority to do. And in Mr. Krakauer's legal arguments, he has suggested that the state of Montana and the university system should just disregard the federal law because of what he argues is the unlikelihood that the federal government would ever remove federal funds. It's our understanding that from a fiduciary responsibility, we have to be a little more responsible and accountable than to conduct our business in a way that just says, let's go ahead and violate the law and then hope for a small penalty. We are in this position of conflict between what a state court has ruled and then what the United States Department of Education says federal law actually provides. So we have no choice but to be in the Supreme Court, given that we were sued in the first place.
And some would say that the situation is moot simply because Mr. Krakauer's book has already been published and released.
That certainly could be the perspective that a lot of folks hold on this. Yes, we're involved in the litigation regardless, given that we've been sued for the information that the Department of Education says we can in no way release.